Hi, this is Josh Blackman. Welcome to the Harlan Institute Virtual Supreme Court competition. This year we are doing the case of Moody versus Net Choice. This will be the seventh match in the semifinal round. Both teams are from Regis High School, New York. For petitioners, we have Colin Jett and William Napoli. And for the respondents, we have Nathaniel Marks and Edward Napoli. Are the Napolis related?
Yes, in fact, we are twins.
You're, I thought so. Well, I will do my best to make sure you're different Zoom boxes. All right. Petitioner, you have 10 minutes. Begin whenever you're ready.
All right. Um, Colin, I will just present the first argument. You can present the second, and then we can see for the third.
That's fine.
So,
You can divide up however you want.
all right. So, in short, our first argument is that for this to, or for the respondent's argument to have merit, they would need to prove that we are in some way inhibiting the free speech of these corporations such that it would be unconstitutional. And in short, we are simply saying that what this regulation is doing doesn't actually inhibit this free speech because it doesn't even constitute speech in the first place. Now, first, we would say that Florida's law, as we write in our brief, regulates what social media companies must do regarding content moderation, not what they must say and what they may not say. We have a few cases which we think prove good precedent to prove this point. For example, one of them is Rumsfeld versus the Forum of Academy and Institutional State. So in this instance, Rumsfeld was requiring schools to allow equal access to military recruiters, and this was not in a violation of the First Amendment free speech requirements, specifically because, for the same reasons that social media platforms would have to allow equal access to politicians, it acts more as a forum for schools to allow these military recruitments on their premises comparatively instead of actually allowing speech on their platform. So, in the same way, in that these schools aren't really speaking, or at least their speech isn't inhibited, they're just allowing or disallowing something to occur on their premises, we can make the same analogous arguments when it comes to the idea of social media platforms and the speech that occurs on their websites. Now, another strong piece of precedent goes to prove our point is in the case of Pruneyard Shopping Center versus Robbins. So in this instance, a group of students set up a table at a shopping center and handed out flyers to spread their political cause. And unfortunately, when they were doing this in the mall, they were forcibly removed. And Pruneyard, who was Pruneyard who had removed them, argued that being unable to regulate the speech inside of their own mall was basically inhibiting their own freedom of speech, and that it was their mall. There were people saying things which they didn't necessarily agree with. So, as the owners of their mall, they should have had right as the owner of this public forum to inhibit and regulate what happens inside.
So,
Now, in
Counsel,
this instance,
if I can interrupt, if I may,
yes,
when we're talking about speech and the freedom of speech, we have to say whose speech. Do you agree that there's speech on both sides of the equation here? There's the speech of people posting stuff on Facebook, but also the argument that Facebook displaying this content is Facebook speech. Isn't there a speech on both sides?
Well, yeah, specifically with, is it fine if I'll answer this? But that specifically, this speech occurring on the platform is not necessarily associated with with the actual speech of the platforms. Specifically, if we look back into the case of Rumsfeld versus academic and institutional rights, the
I get,
reason
but my question is a little more specific. Facebook says that they're engaging in speech. Why are they wrong?
because specifically removing someone's speech doesn't act it's not acting as their own speech.
For sure.
They
I get that about removing the speech. My question is a little bit different. My question is this. Um, Facebook says when they curate all these different feeds with all this different content, that curation is their speech. Why is that argument wrong?
Colin, could I respond to this briefly?
sure.
I would say that you're going to, or this is argument that's basically similar to the idea of the newspapers and editorial discretion, in which you could make a similar argument. Newspapers, of course, they do all this moderation, they do all this conglomeration of materials, they publish it. And in that instance, you could make the argument that editorial discretion makes it so that that is speech. However, for social media companies, we would argue that's a completely different story because you don't have the same level of moderation and regulation. For example, if I wanted to get my opinion or just any comment that I would like published on a newspaper like the New York Times or even just a small one, it would take a fair amount of effort. I would actually have to get it published. I'd have to run it by editors. But if I wanted to go on Facebook and post whatever I like, it's very simple. In a matter of seconds, I could simply write a post and do that. So there's a clear difference in the amount of efforts that put in what comparing editorial discretion, what we see on social media. So we would say that this comparison of these social media companies actually making speech simply isn't analogous.
But why does that matter? In other words, maybe talk for a bit about Miami Herald versus Tornillo. Talk about that case for a bit, if you will. I think you referenced it.
Okay, yes, thank you for allowing us to discuss this. So in this instance, we're basically calling on the precedent that a newspaper is described as more than a passive receptacle or conduit for news, content, and advertising. So our argument here is that social media companies are far more similar to this passive receptacle for conduit or conduit for news, comments, and advertising than a newspaper is, because a newspaper would have to determine exactly what goes into every article, exactly how each, I guess, journal article is written, sized. There's far more effort and formatting that goes into editorial discretion that's discussed in Miami Herald Publishing versus Tornillo compared to Facebook. So, on this argument for editorial discretion, because a newspaper is more than a passive receptacle and something like Facebook is functionally a passive receptacle, we would say that there's a clear dissimilarity.
You're getting the right language, right? Passive receptacle. But why is a Facebook passive receptacle? There are algorithms that choose different content based on Facebook's preferences. Why is that passive?
I would say it's not, or it takes significantly less effort than newspaper, and that you
Agreed, less
can't have
effort, but why does the fact that it's less effort make it no longer speech?
well,
Yeah.
you'd like to answer that?
Yeah, I think one and this is definitely an argument we are going to get later into it, is that for it to be identified, there has to be an identifiable message resulting from this resulting from this moderation. And a lot of times what we see, we're looking at either pre-screening and post-screening. And when we're looking at post-screening, when a user interacts with this, they don't immediately identify this speech with Facebook. This isn't Facebook speech. This isn't identified by anyone reasonably to be Facebook speech. And even though their algorithm,
Or who you're identifying the speech with. If the New York Times runs a commercial, for a fundraiser, that's the fundraiser's thing. It's not the New York Times speech. Why does that? Why does it matter who it identifies with?
I would actually contend to disagree with that point. I would say that the authors which are hosted on different newspapers basically define how people view the newspapers themselves. And then, for example, New York Times, someone would say that it has a slight left-leaning bias because they consistently have people who write for them and represent New York Times as possibly like the slightly left-leaning. However, even if a lot of people who were on Twitter, or even the majority, were left-leaning or just had some sort of political affiliation, I think it's a greater leap to say that that platform itself is actually left leaning or expresses that opinion. Because when you're writing for an editorial, you are, in a way, an ambassador for that editorial in a way that you aren't for social media companies.
Why can't Facebook say that we want to endorse a particular political perspective? We want to endorse certain views on, I don't know, vaccines or COVID or anything else. Why can't Facebook do that as a company?
nothing is stopping Facebook from endorsing these views. If Facebook wants to put a huge banner the second you click on your website saying, this is our specific views on vaccination, this is our specific views on this political election, and we endorse this specific candidate for president, there's nothing in this bill that prevents them from doing that. These companies are still perfectly allowed to express their views on anything. But what this only allows them to do is make sure that they have people allowed to use their platform to say their opinions. It doesn't prevent them from expressing their own.
Describe me how the law operates. The Florida law.
Sorry, can you repeat that question?
Can you please describe how the Florida law operates? What does the Florida law actually do?
So basically, the Florida law operates on, they have two specific broad bans on censorship and deplatforming. So specifically on censorship, there's not a ban on censorship. But what there is done is it argues there must be a reason provided for an individualized reason to allow there to be speech to be made without just being struck down without a specific reason, but also in the case of deplatforming with political candidates, that candidates are not to be removed from the platform for over 15 days in a complete ban, or there will be financial penalties.
Counselor, that sounds a bit like compelled speech. Can you talk to that a bit?
Yeah, so for it to be compelled speech, what you have to argue then is that the action of banning or not banning is speech. And ultimately, you have to look back to our previous arguments on how the banning is not speech. If we look at cases like Prunefeld, or in specifically, if you look at Pruneyard Shopping Center or Rumsfeld, what we see is that again and again, the precedent indicates that allowing or not allowing speech on your premises is not an action of speech itself, due to the fact if you still have the ability to differentiate yourself from these opinions, as social media companies still do have the ability to express their political opinions or opinions on any other matters. And this law does nothing to prevent that.
So to just briefly touch on that, it also gets into the area of what is expressive and isn't expressive speech. And even though we have only 20 seconds left, we are going to talk about that later in our speech, but just to understand that there is a boundary between what is and isn't expressive. We're going to try to clear that up and explain why this really doesn't count as expressive speech in our next speech.
Okay, thank you. Time is just about up. Respondents, you have your 15 minutes. Whenever you're ready, you may begin.
Sorry, there's some sirens.
New York, I know. I'm from Staten Island. I get it.
Thank you, Mr. Chief Justice, and may it please the court. Florida's bill attempts to deconstruct one of the keystones of the architecture of constitutional ordered liberty, the First Amendment's guarantee of free speech. That guarantee fundamentally protects the ability to speak in ways that one chooses, and inversely, to not speak in ways that one does not choose. Florida's SB 7072 violates both of these principles for the purpose of discriminating against a perceived viewpoint, and its justifications for doing so are not grounded in law or fact. When tested under the correct standard of scrutiny, it fails with flying colors.
Social media companies emit very little content of their own. Instead, the vast majority of speech on their sites is produced by others, to the tune of tens to hundreds of thousands of videos and images a day. Social media platforms, however, still express their own opinions, not through the production of their own content, but through the removal of other content. Social media platforms moderate content regularly that violates their rules and guidelines, all in an effort to express disapproval of certain hateful or misinformative views. Those actions are indeed conduct sufficiently imbued with elements of communication to be protected by the First Amendment, as per Texas v. Johnson held. It is the right of platforms to exercise their freedom of speech through these actions, despite Florida's bill.
This court has repeatedly held that private entities in control of private fora of speech may exercise editorial discretion over the speech therein, choosing what is expressed and not expressed. In Miami Herald Publishing Company versus Tornillo, this court established the editorial discretion doctrine and stated that even if a law provides no additional burdens on a particular organization, if it prevents that private fora from exercising control over speech in it, the bill is invalid. In Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, this court expanded that doctrine, finding that editorial discretion need not result in a particularized message to be valid. Most recently, in Manhattan Community Access Corporation versus Halleck, this court expanded that doctrine even further, finding private fora may generally exercise discretion over content that they themselves did not produce. This right to editorial discretion is clear in this court's case law, but Florida's bill violates it.
If I could jump in, please.
Of course.
So on the other side, your friends also cite Trinillo, but they say that Trinillo applied to a newspaper, but Facebook and social media is different. And they call Facebook and social media a passive receptacle. That's a phrase that they kept using. Could you respond to that, please?
Sure, I can respond to that. Well, first, we'd like to say Trinillo's doctrine has been cross-applied to many other instances, as we cite with Hurley versus. Sorry, what did you say?
Both holding has been what? Use the word. I didn't hear the word. I'm sorry.
Oh, the Trinillo doctrine, basically of editorial discretion, has been cross-applied to many other examples other than, say, newspapers, as we did cite Hurley versus Irish American Gay, Lesbian, Bisexual Group of Boston. Those cross-applied there were, in that instance, it applied to a parade and the parade organizer's right to.
I get that. I get that. But a parade is very clearly speech, right? You're endorsing a message, right?
Sure.
Our parade. I'm asking, how is Facebook, how is a social media platform like a parade, like a newspaper? This seems different to me.
Well, the reasoning here is that these social media companies do actually express their own views through the actions that they take to choose which speech is there and isn't there. So for these parade organizers, these parades did not have certain groups that went on the parade. They accepted certain groups into their parade. And for Manhattan Community Access Corporation, we show that this corporation did not create the content that they ultimately prevented from going on airwaves, but instead received that content and censored it out. I'm sorry.
Do anything before allowing a person to post? Do they have any sort of screening, or they just let you post whatever you want?
Well, I mean, they present their views and rules and guidelines up front. one of the requirements for being on these social media platforms is that you abide by their rules and guidelines. They tell you upfront that here are their views and here are the actions that they will take to protect those views.
All right, I mean, so
Mm.
let's just be real for a minute, right? Has anyone ever actually read those rules? I mean, I've never read them, completely honest. Maybe you have. You guys are smarter than me, right? But for the average person in the street, they make a Facebook account, they post whatever garbage they want, and then they never think about it ever again. So I mean, is this really the same thing as a newspaper exercising editorial judgment? I mean, just be honest here.
Well, even if people do ignore these guidelines, which I would never ignore these guidelines myself, but even if people did do so, we do still think that the precedent of this court is squarely on our side. So just citing back just a few years ago, I'm just going to use the acronym now, MCAC versus Halleck, there was content from an outside producer that was critical of this news corporation, and it was aired once, and then the corporation's like, maybe we shouldn't be airing stuff critical of ourselves. And so they shut that down. That was not content that they had produced. That was not content that they upfront really screened. But on the back end, for release, for display to the world, they still had the ability of editorial discretion to moderate what kind of content was shown on their airwaves and what was not.
Right.
And
Well,
we think that
so let's say that I assume you're right. Let's say that in fact there is speech by Facebook and Twitter. But what about Pruneyard? How do you respond to the Pruneyard case, which was mentioned by your friend on the other side?
Sure. So the background for the Pruneyard example was you have the shopping mall center, and there are students who basically want to spread handbills at the shopping yard center, but the people who run the center have basically disallowed any sort of spreading of these handbills. So the students sued under their First Amendment rights, and they actually won. Now, what differentiates Pruneyard from this example is a few different things. Firstly, the owners or operators of the shopping mall had a broad disallowing of any sort of handbill spreading. So it's not in the sense where they're trying to expressly sort of moderate what handbills are being spread. They're either allowing any handbills to be spread or disallowing any. So it's not a reasonable extension of their expression of their own viewpoints.
Forum, right? A forum is a private. I'm sorry, a shopping mall is a private business, right? You go there, you have Macy's, you have JCPenney, right? You have stores, you go shopping. But if a private business opens itself up for people in the community to distribute literature, it sort of becomes either a public forum or maybe a limited public forum, right? So couldn't it be argued that Facebook, by opening up to basically anyone who creates an account, is sort of converting itself from a private forum to some sort of public forum?
That's another interesting thing to discuss. In Pruneyard specifically, they cited that anyone could enter and leave the shopping mall. So it was, in that sense, an open forum. But in the case of these social media companies, as we did mention, there are terms and services and regulations that you have to follow to remain within these platforms and to enter initially. So we do think that's a different type of scenario.
I pick up on the terms of service question. Obviously, if you enter onto a train, they don't say they have terms of service, but obviously if you make a ruckus in the train, if you disturb the peace in some manner, if you do something that violates the train's guidelines or terms of service, if you will, they're free to remove you, even though they may be a common carrier, for example. So could you maybe elaborate on why the terms of service specifically exclude things from being considered a private?
So I think the point here, I'm sorry, I'm kind of unclear on the question, but I think that this is differentiated from those kinds of rules and guidelines, and that those rules generally prevent non-speech actions. I mean, yelling on a train generally is not protected by free speech. Causing a ruckus, public disruptions are not necessarily protected by the First Amendment. And these social media companies are not common carriers, either established.
I mean, I want to push on that one a bit. I think the other side does argue that the sort of market share that Facebook and Instagram and Twitter have acquired puts them in the ballpark of being like a common carrier. Why do you think that position is incorrect?
So there are many descriptors that have been applied to common carriers. They serve the public, they're public interests, they have lots of market power. But these kinds of things apply to a great many services. Those things are not generally considered to be.
Can you repeat the definition of a common carrier, please?
I would love to repeat that definition to you if one in fact existed. So the definition of common carrier, it could just be a really big company. It could be one that serves all comers. It could be a public service, whatever that may mean. It could have monopolistic influence. It could receive special government favors. Throughout time, various definitions of common carrier have been favored at one point or another. Justice Thomas recently restated quite a few of them in Biden versus Knight First Amendment Institute. But regardless of which definition you may think is correct, there have always been, say, exceptions that may disprove the rule. So it's true that these social media companies have lots of market power, but there are other social media companies that also have market power. In our brief, we give examples of smaller social media companies that, while smaller, still exhibit large shares of market power.
Who does this law apply to? Does it apply to all social media companies?
It applies to, I believe, larger social media companies.
And isn't that the ones with the problem if a small social media company doesn't have sort of the market share that requires this intervention?
I'm sorry?
But isn't that a good thing? There's some smaller companies that are not regulated, but this law only applies to the bigger companies that might justify some intervention.
Well, irregardless of whether it is applying to a smaller or a larger company, it is still in violation of those larger companies' First Amendment rights. To say that a larger company may necessarily need.
Right, but if these are common carriers, right? If these actually in fact are common carriers, then they can't complain that they're operating for the public good and they can be regulated. Why doesn't the definition really matter for what a common carrier is?
I think it does. And then I guess that goes back to the point that we'd push back on the fact that these companies are actually common carriers. As we said, the definition has been very vague over time. There have been certain notions of serving the public interest or a common good for the people. But over time, this has fallen under the category of many different industries, such as things like textile manufacturing, it's just things like hospitals, road production. So there's no one set definition. And as we can see, many of these companies don't necessarily operate in the sense where they're solely for the common good, and they're not really monopolistic, as they do have ample competition on both sides of the political spectrum.
So it might be true that they don't have, they don't necessarily operate for the public good, fully, but they do serve as a large public forum. We said that in Hacking Him. We also have noted that that social media companies are so large that maybe it might be worth that just stretching the definition of common carrier. I know that's probably something that you're opposed to, but can you elaborate as to sort of why social media companies specifically should be excluded when we consider the history of speech in this country and how important it is to sort of get your message across on the internet, which is the forum of today.
So I think the road to government over intervention in rights is paved with good intentions, which is that though it may be a noble goal to protect free speech rights, stretching the definition of common carriers beyond what it ought to be, whatever that definition may be, stretching it too far to pursue the protection of certain views. And we show that this bill was meant primarily to protect conservative voices in social media. Stretching it too far one way or another and then justifying it on the back end with the goal of fostering greater free speech, we think that that's something that's probably pretty dangerous. These social media companies, regardless of what you want to say they are, if they're big, if they're serving a public interest, if they have government favors, regardless of what your definition of a common carrier is, we do not believe that these social media companies meet those definitions. Because if you look at the history of common carriers, the definition never really applies to what we see social media companies are today. And stretching that definition.
Why must that definition be fixed though? Because there was never a telephone company till there's a telephone company, right? There was no electricity company till there's electricity companies, right? This is a new thing. It exercises great market power, right? It's very hard for new entrants to break into the field. Facebook, Florida's not telling Facebook what they can and can't post. All they're saying is if you take down content, you must give it an explanation. Why is that so unreasonable?
Well, do you want to actually handle this one?
Sure, I can talk about this.
Nodding the other side, but yeah, it's supposed to be camera sensor, camera's supposed to be off, but it's okay.
Oh, sorry, what happened?
Nothing.
Oh,
but
so,
why
I think
is it so unreasonable? Why is it so unreasonable for them simply to say Give an explanation when you take down content. Why is that so unreasonable?
Oh, specifically for the mandated
Yeah, for Florida,
reasoning.
yeah. Why is that such an unreasonable requirement?
Sorry, could you repeat the question? I think I got it.
I think I got the question.
Okay.
So these social media companies take thousands of actions in content moderation each day. And this bill's requirements for what they actually have to disclose as reasoning for such actions, it's it might be vaguer than the definition of a common carrier, frankly. They're very, very vague definitions. They want thorough rationales, they want precise and thorough explanations of how they came to make these decisions. And what we're saying that when you have decisions to the tune of thousands every day, when you have such vague requirements, and when you have the Zotterer standard, which asks for only factual and uncontroversial information that is not unduly burdensome, we think that this falls far beyond the pale of what disclosures can be legally mandated. And we think that that is really something that violates the compelled speech doctrine. You're compelling these companies to say things that they otherwise would not like to say.
Okay, thank you for your time. Petitioners,
Thank you.
5 minutes whenever you're ready.
Okay. Through this 5 minutes, I'm just going to try to clear up a few points. It seems as though the central issue of this debate has come down to whether social media errs towards the side of editorial discretion or being a broadcast form of public forum. And in fact, if it was a broadcasted or public forum, then it seems as though we would be winning the debate. And if it was a newspaper, then editorial discretion would win my opponents the debate. Now, I think there are a few good independent reasons to believe that social media companies err towards the sides of social media being public forums and broadcasting compared to being editorial discretion as for newspapers. And the first reason for this is in the precedent of Packingham versus North Carolina, where the court specifically describes social media companies as a vital form of speaking and listening in the public square. And I think this also makes the most sense given the other arguments that were given. But this is just to prove that the social media companies, as have previously been described, fits more in the idea of the public square. Now, why exactly is this important? Firstly, it's important because public squares simply don't receive the same level of moderation and don't really have the same speech
I can interrupt
that
you.
non-public forums have. Sure.
Uh,
Yeah.
When you say public square, are you referring to a public forum or using public square differently?
I'm using the term public square as is found in Packingham versus North Carolina, and I would contend that it fits most with the idea of a public forum in which
And how did
it's just
let me come back to
open.
this part. How does Facebook become a public forum when there are these very stringent terms of service that were discussed that you need to agree to go there? If I walk into a park, I don't have to like check a box saying I agree to a 50-page document. But if you want to use Facebook, you do.
Yeah, well, I think specifically, a lot of times we look at Facebook as, it may seem burdensome, oh, this 50-page document, but what that really is within the context of clicking thousands of buttons to view a social media, you click one button that says yes. This is not some extremely burdensome process to enter. This is not a hard,
But the fact that these terms exist make this different from a public forum,
well, every public forum has terms that may not be specifically regulating speech, but by clicking yes, I agree when you enter a website, this does not create this as some private space. As the
But
clicking
when you click yes, you're creating a contract. I mean, you're waiving rights to sue, you're giving rights to a jury trial. I mean, if you maybe I haven't read it, but I assume it's in there. You're giving up a lot of stuff, and you don't have to do this. If you decline, then don't use Facebook. So I think there is.
Well, I would say that. Sorry.
Check box. Go ahead.
I would say to that point that if we look to your example, I think of the subway, even though you don't have to sign a terms of service when you go into the subway, if you make a ruckus and if you disturb the peace and do unruly things, then it's very likely that you would be kicked out of the subway. So in all ways, or at least in many ways, for public forums, we sign inherent social contracts when we enter them, but that doesn't discredit the fact that there is still a public forum in the first place.
All right, may I continue?
Okay. So the second piece of evidence that we would believe proves that social media companies are closest to the idea of a public forum or a broadcasting center is the idea of journals versus websites. So as I give the example in my previous speech, if you see that New York Times posts an article of something, the author is in essence acting as an ambassador for that website. You can implicitly know this when you say that people say that certain websites have left or right-leaning biases because the articles truly represent the websites. However, if you go on Twitter, no one would actually think that a person on Twitter represents the company of Twitter because they have an inherent status as an individual compared to representing the company.
I mean, is that really true? You could have a certain senator from Arkansas submit an op-ed to the New York Times, and I guarantee you the New York Times completely disagrees with that. I'm not sure that that's correct.
Well, I mean, I guess there is a bit of leeway in what companies do and don't put on their websites. However, I think my point still stands insofar as people do ascribe certain biases and do ascribe certain ideologies to websites that would make editorial discretion apply. So my main point here is simply that we don't see the same type of editorial discretion apply when we see social media companies. And another example, or at least another point that I think would work as evidence against this, is that we can still have all sorts of censorship on these social media platforms. All we're saying is that they need a good reason for the censorship to exist. For example, if you still disagree with the message, there's nothing stopping like Twitter from making a little community note saying this information is invalid insofar as they actually have evidence and they have a good reason for believing that. So I think that at that point, this bill becomes a very reasonable restriction on companies from inhibiting free speech and does not actually harm free speech in the way that my respondents say it does.
Okay. Thank you so much. The case is submitted. All right. Can everybody please come back on camera? Very good. So first off, stop the timer. Sorry, we are over time. So first off, congratulations. I know this is very hard. It's probably different than any of the debate you've done in different clubs. You're nodding, which is good. I treat this the same way I treat a law school exercise. These are my law students. They will agree that I am as hard on you who are 17, wait, juniors, seniors. What year are you?
We're all sophomores.
Sophomores. So what, 14, 15 years old?
16.
Close enough, right? You're all 16 years old. I treat you the same way I treat a bunch of law students, so it's not easy. But you handled it well. What I liked was that you had both case arguments and policy arguments. What I mean by that is you were able to give me Supreme Court decisions that you think were on point and describe the facts of them. But also you were able to pivot. And when we're talking about what's a common carrier and things that aren't really defined in the law, you're able to sort of adjust on the fly, which was very helpful. Some feedback. Again, I'm from New York, and so I know this well. There's a courtroom demeanor that you have to just learn. When a judge asks a question, don't say yeah. It's yes, Your Honor. Every sentence begins yes, Your Honor, no, Your Honor. It's just automatic. I took diction lessons to get rid of my New York accent. It took me years, but eventually look at all these balloons. What is that? Zoom is apparently anti-New York. They're celebrating my shunning of my New Yorkness, right? But maybe you'll stay in New York your entire lives, so it'll work. But if you sort of leave New York, you'll just be cognizant that there's a certain demeanor. What is this balloons? I don't know what's going on. I have no idea what these balloons are. Stop. Another related thing is, and this was for the petitioners in particular, when you begin, you always have to say, Mr. Chief Justice, may it please the court, right? That's the first words out of your mouth, not I'd like to talk about whatever, right? So you have to have a very sort of formal beginning. It was kind of funny that your camera's on because I think you really like my question. You're like, yeah. But it's a good rule when you're a lawyer and the other side speaking, right? To just sit there quietly and not show any emotion. And Daniel's nodding his head. He's a moot court on our moot court board. You don't want to show that you're kind of like rubbing it in. It's like, oh yeah, the other side's really giving to you because you know what? You're gonna be up at the big table soon. You might get hard also, and you don't want the other side to come after you and like gloat about this. So just have a very flat demeanor, which is why I usually say just turn your cameras off so you don't have to worry about it. But you know, just by the chance your cameras were on, so we saw it. I think you both were pretty well versed on the facts of the law. One sort of just technical issue, and this might be a Zoom problem, but when you hear this camera does not want to stay in place. When you hear a question being asked, you to stop talking immediately. And there were a couple of times I noticed that you were sort of talking over us. Then maybe because of the Zoom latency, and I'm willing to sort of blame it on the tech. But the other rounds haven't had that issue with other students we've done yesterday. So maybe it's just the the New York is shadow banning me. They're downgrading my bandwidth. But I think you have to just be a little bit more cognizant that if you even hear, even if you see that our mouths are moving, which you have a camera, you just got to stop, right? You just have to full stop. Don't say another word. I actually like there's a little bit of humor about whether you actually read the terms of service. Like I would always read it. Humor is sort of risky, but if you do it well, it can work. But you have to just be careful that if a joke falls flat, you've wasted your time because you haven't made a point and you may have just annoyed the judge. Your opening statements, petitioner in particular, you kind of just walk through these cases. I think you can presume that we're familiar with the cases. We don't need like a 2-minute recitation what these cases say. When you get 2 minutes at the outset to give your position, you should be very deliberate to lay out exactly why you should win. And I think at one point you said, we'll get to this later. And you said this after about 10 minutes of arguing. And you're not going to, right? Or maybe you did, but don't say we'll get to it later because that sort of annoys the judge because like, why didn't you already do it if it's so important? Do it now. Keep an eye on the clock. And if you're something that's really important, find a way to work it in before you're down to 10 seconds. You have to save it for rebuttal. Because there's no guarantees in rebuttal. We let you talk. We can just ask you questions as we did. I'm not sure if you even got to that point. Maybe you did. I don't remember. Those are my comments. Alex and Dan, to give.
Pretty much everything I had written down, Professor Blackman already talked about the not talking the second a judge asks a question, and more on the getting to it later part. You never want to overpromise something that you don't get to because then you look a little unprepared. So if you say get to it later, make sure you get to it. And if a judge brings it up, don't say we'll get to it later because the judge wants to talk about it and that's the only thing you should be talking about at that point.
Yeah, I'll pause just briefly, Daniel. Whenever a student asks me a question, I say, I'll get to it later in class, or I'll get to it next week. You've heard that, right? Do you hate that answer? Oh, I do. So I know students hate when I say that. Sometimes I really can't do it because I have time. But it's the same idea. It's like, no, I want it now. Go on, Daniel.
Yeah, and in a courtroom, you're there to be helpful to the judge. So never try to push things down the road. But other than that, great job. Clearly, both teams are very well versed in the subject matter. So great job.
Alex?
Yeah, I agree. I did a lot of parliamentary style and CX style debate in high school. So I understand like when you're asking, when you're answering questions or getting asked a question, you sort of do that on your own time. But when you're communicating with the judge, like they said, you just want to stop talking immediately. There was a couple of times I tried to politely, cut you off, but that's just something that you'll pick up with time, especially as you see more etiquette in the courtroom. As far as the actual substance stuff, I really liked what I saw here. I thought both of you were excellent. I thought y'all were responsive to each other's cases, which was really important. And I thought that y'all obviously had a pretty substantial knowledge of the case law. I appreciated that you brought up new cases, the Manhattan Community Access case. That was a new one that I haven't actually seen a lot of students talk about. So
it's a good case. It's only a couple years old. A couple other points on the sort of the substance, or just the polish. There are two views sitting next to each other. The other two, what's with these balloons? I have no idea what's going on. The handoff between them needs to be a little bit more seamless. You kind of look at, do you want to do this one? I saw you kind of looking at each other. What a lot of teams do, they just alternate, right? I have no idea what these balloons are, right? Student one does the first question, then student does the second question, you just alternate. And you kind of looked at each other. If in future rounds you can be in the same room, I know you're all in New York, but New York's a big place. But if you could just be in the same room, it does help to sort of make the handoff a little bit easier. And I have no idea, these balloons are bothering me. But the substance I thought was actually pretty strong, and I think you both have a good command of the issues. That's all I wanted to say. Just some questions for us that you want us to think about or answer? Anything at all, whatever's in your mind?
Just a question, Professor Blackman, about like talking to judges, like cutting yourself off, answering these questions. Is there a better way to kind of transition from speaking into answering into speaking again?
Daniel, what did they tell you about moot court? I mean, that's something you talked about in moot court board.
So after the judge starts talking, stop talking immediately.
Yeah.
Then after the judge finishes, the first word that should come out of your mouth is either yes, no, or the way we teach it here is try to rephrase it, the judge's question. Yeah, try to rephrase. So yes, no, or rephrase. Use the rephrase sparingly, but quickly answer the judge's question, then immediately try to pivot using some sort of transition to go back to what you're initially talking about. So I like to say, returning to my second point, and granted, a lot of judges will say, no, 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 I want to keep talking about what we're talking about. Then you just have to go where they take you. So it can be hard to try to get back into the substance, but just keep a mental roadmap of what you want to say, usually 1, 2, 3. If they cut you off on 2 and bring you into 3, talk about 3 for a little bit. If you can get back to 2, do it, but if not, then you just got to kind of work with what you're given.
Very good.
Thank you.
Yeah, I get your your question. It's actually a very good question. The hardest thing to do is to shut your mouth as you hear a voice, because you have this answer, you're ready for it, you want to give it, but when the question comes in, what you're saying has to stop. What becomes difficult is after the judge stops speaking, if you get on the fly, think of a way to embed what you wanted to say in response to what the judge was asking you, right? There's, you have to be responsive, you have to answer the judge's question, but you can still work in the thing that you wanted to say originally. And that takes talent, that takes skill, right? It's hard to do that. Sorry, I can't get a good camera for some reason. The camera just not want to sit. All right. What other questions do you have for us today?
So,
I wish we had more, but I don't think so.
no.
I came in expecting to be asked questions, not to ask.
Exactly.
Oh, okay, that's fair. I don't put you on the spot. Well, that's all we have. Thank you so much. We'll be posting this course later this week, and I wish you all the best of luck, and please keep in touch.
Thank
Thank
you.
you.
Thank you very much, Professor Blackman.
Good luck to you all.